A creditor will garnish a debtor's wages after getting a judgment. And that's because we have a protection in the United States called due process. If somebody takes money from you without due process of law, the English word we use to describe that is theft. So if you owe creditor ABC, say $10,000, initially what will happen is creditor ABC will try to get you to pay. And they'll send you letters, call you on the telephone. If that doesn't do the trick, then typically they'll either retain the services of a collection agency, or more likely, they'll sell the debt to a collection agency. And then what will appear on your credit reports is a term called charge-off. Now, people sometimes misinterpret that phrase to mean that the debt has ceased to exist. That is incorrect. All that's happened is the creditor has sold the debt, and you can be sure that they sold it for a good deal less than the face value of the debt. So creditor calls Dewey, Cheatham, and Howe down the street and says, hey, we've got this $10,000 debt. You want to buy it? Dewey says, sure, we'll pay $500 for it. $500? This is a $10,000 debt. Yeah, you haven't been able to collect it, so we'll pay you $500. So creditor ABC sells it to Dewey, and now they've had a loss of $9,500. Well, they'd like to get a tax benefit. Bad debt should be used to lower their gross taxable income and, as a result, concomitantly lower their tax liability. And as evidence of that, then they will report in your credit reports that the debt has been charged off. Now, Dewey has this debt. Can they collect only $500? Oh no, face value of that debt is $10,000. So they will try to collect $10,000 from you. Now, usually they'll use as a tactic contacting you to say, well, you owe our client $10,000, but we've been authorized to settle for $7,500. This is a savings to you of $2,500. But we must receive payment in full within 30 days, or we'll have to take appropriate action. It's usually vaguely worded. If that doesn't do the trick, then the next communication is typically somewhat disappointed in tone. I don't understand it. I offered you this really great deal to reduce your liability to my client by $2,500. Why didn't you take me up on it? But I have been authorized to extend this for 30 more days. But we must receive payment in full immediately. Otherwise, we'll have to take legal action. And typically what will be happening at the same time is a succession of phone calls. You'll get calls all day long. There are limits in the Fair Debt Collection Practices Act to the times of day that the creditor can call you, and if you have problems with your employer, they can't call you at work. But they are really quite persistent. And if that doesn't produce payment, then eventually they will file a lawsuit against you. And if you want to defend, you'll have 30 days to file a written response. If you don't, then sometime after that, the creditor will file another document after that complaint that initiated the lawsuit. That second document is called a request for default judgment. And if you don't take action on that, the clerk of the court will enter a default judgment. With that default judgment, the creditor can enlist the services of the sheriff to contact your payroll department to initiate a wage garnishment. Now, the creditor can also record a lien against assets you have, typically real estate if you own your home. And so the creditor isn't completely without recourse. Creditor can also enlist the services of the sheriff to levy funds out of your bank account. Now that is instantaneous. You'll get no warning whatsoever. The vacuum cleaner hits the bank account and it's empty. At least with wage garnishment, you'll typically get 1 or 2 pay cycles warning before the wage garnishment starts. And then that will be a judgment garnishment, and that will persist until either you file for bankruptcy protection, which will stop the wage garnishment, or you pay the debt in full.